Hello, my name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors. Today I'm making a presentation on wills. What is a will? Who needs a will? Why do you need a will? And how do you make a will? A will is a legal document that someone makes in anticipation of death. Death is certain, although we do not know the terms. So, in anticipation of death, we do make a will, a legal document that is there to provide for when we die, so that your assets and your children will be managed when you've passed on. So, it is a legal document stating how assets are distributed after death, which appoints the executors and guardians for your children. And there are legal requirements that are there for a will, which include that it must be in writing, signed and witnessed by two independent adults if you are in England. Who requires a will? Anyone who has got properties, investment, assets, savings, children, and who has got any specific distribution wishes. People with a complex life, everyone needs a will. Even if you just want to make a will to outline what you want to happen on your funeral, if you want to make a will on who is going to stay with your children and how your property is going to be distributed, you still need a will. So, a will is there for anyone who wants their intentions to be respected when they pass away. Obviously, when we're advising you as lawyers, we advise you on how to legally make your intentions be known to the executors, to the world. So everyone needs a will. I will not comment on complex wills because it will be outside of this presentation. But in general, these are the categories of people who need a will. So, who can make a will? A will can be made by any adult of sound mind. And again, there are some complexities that are there which are outside of this presentation. A will must be made voluntarily and without coercion. And a will can be updated or revoked at any time, especially when someone has got capacity. Capacity is always something that is important when making a will, and so is legal requirements of making a will. So anyone above the age of 18 and is of sound mind can make a will. There are certain special wills that I will not comment on today that can be outside of this jurisdiction. But let's speak of simple wills and maybe mirror wills for this time only. What are the benefits of making a will? A will is there to distribute your assets as per your wishes. So if you have got children, you have got relatives, you have got assets, and you want it to be distributed however you want it to be distributed, you have to make your intentions be put in a will. Or anyone who is dependent on you can also be included on a will. You can also make donations. A lot of people make donations to charities, they make donations to their churches, to their mosque, or things like that. But you can make your wishes known through a will, and your assets will be distributed likewise through a will. In a will, you can appoint executors and guardians. So, executors are the people that will manage your will when you've passed on. Sometimes the executors might also be known as trustees if the will includes a trust. So you need executors, but it can be a single person or more than a single person. More people can be executors. And if you've got children that are at the age of 18 or people that are dependent on you but don't have mental capacity, then you can also wish to include guardians in the will. It is important to have a will because with a will, it reduces family disputes and delays. Where there's no will, people might start fighting for the assets. And if you die without a will, we say you have died intestate and you have not appointed executors, so administrators will be appointed. And it has to follow the law, not your intentions, because there's the law on intestacy that needs to be followed if you have not done your will. A will also enables you to give charities and to also give your funeral directions. This is important to have your funeral directions be known, particularly if you are someone who has had a number of um, habitual residents. You've been resident in the UK, you've been resident in Africa, Zimbabwe, Malawi, wherever it is, and people don't really know where to bury you. So if you put your own funeral directions, people will follow that. Not only that, it will also be beneficial if you want to let people know how your body is going to be dealt with. Some people give their bodies or part of their bodies for research, and if it is not in a will because of religious reasons or because of spiritual reasons, some people might refuse to release your body. But if it's mentioned, then they should respect the will. A will is also an important tool for your life to assist you with your tax planning. We know that there's other taxes that are there, such as inheritance tax, capital gains tax, and other taxes that are there. And while you're still alive, there's all those things like tax planning, where you can give to people, and the gifts, if they fall outside the 7 year period, then they will not be part of your inheritance. Certain small gifts can be given annually to your relatives, your children, and so forth. So it will assist you with tax planning if you have got a will. What are the disadvantages of not having a will? If you do not have a will, then assets are distributed according to intestate laws, and these are not your wishes. So intestate laws will regulate who is going to benefit, how they are going to benefit, what percentage are they going to benefit, and people might end up having quarrels because there's no laid wishes from yourself. The court will help you, or the system will help you to get someone who will be an administrator or administrators to execute or to manage the intestate estate. You would not have said the person who's going to be a guardianship of your children. So again, you have to follow the letters of the law, because you cannot be able to determine it because you're now deceased and you have not made it whilst you're still alive. There's always delays, and there's always higher costs when it comes to issues when you're dealing with intestacy. My point and my advice to everyone listening is that you need to have a will. It's important for you to have a will, so that your affairs are dealt with accordingly in terms of your wishes, and in a most likely less to be um, expensive way, unless if there's going to be disputes between the beneficiaries, or if there's going to be a challenge of your will one way or the other. But all things being equal, having a will is better than not having a will at all. I always get asked by my clients, what are the costs of making a will? So if you go to a solicitor and you make what is termed a simple will, and a simple will is normally defined by whoever solicitor you are dealing with, or a lawyer, or a person who is authorized to make a will. There's quite a number of professionals that have trained to draft wills. Some just specialize in drafting wills. Some do it as part of a general practice. But if you are going to have a will, you're looking a simple will between 150 to 300 pounds plus VAT. A complex will, might which involves trust and foreign assets, you are looking at a starting point of about 500 pounds to £1,000 plus. They are some wheels that I have seen in shops and or online, which are called DIY kits. They start from about £20 to £100. But there is a danger when you are dealing with DIY kits, because they are too general, they're too voluminous. Sometimes they're trying to cover for everything, and sometimes they miss some certain important aspects of a wheel. So you need to be very careful if you're going to use a DIY wheel to do it yourself. Other costs that might be available when you're making a will, you're speaking of storage. If you are storing them in a wills bank, you are storing them with your solicitor or your accountant or with your bank, you have to make sure that you have discussed the issue of the storage, and the storage costs. And there's also costs in updating the will. You might update it by making a new will, or by making an annexure or an addendum to the will. And there's also other costs that are involved, which are costs of probate. Probate is actually now dealing with the actual estate, who's dealing with the estate, the persons that have been nominated in the will. The executors go through the process of probate to identify your assets, to identify your liabilities, distribute them accordingly, pay out whatever liabilities that you have. So those are some of the other costs. If you're using a professional executor, they might charge for their services and so forth. So there is all those costs that might be linked to a will. But likewise, these costs, apart from the storage one and the updates one, they also appear to a situation where someone has not made a will. So if you've died in the state, you still go through the process of probate. I deal with a number of people, and some of the people have got assets outside of the UK, and some have got assets in the UK only. So when I am dealing with someone who has got assets outside the UK, I have to make sure to ask them what country is it? Does it follow the English jurisdiction? Does it have a different jurisdiction? And so forth. But whatever it is, we know that there is some differences that are always there in each jurisdiction when it comes to issues of inheritance, in issues of wills and so forth. Here in the UK, we've got the Wills Act, and other laws that are applicable to look after the family, etc. So it is important to decide whether to do a single will or to do at least one or more wills, and one will being for each jurisdiction, but cross-referencing the other will in the other jurisdiction. So it's important, as I've said before, that you need to have legal advice on whether you will have a single will or you will have two or more wills, depending on how many jurisdictions you've got properties in. So, if you've got properties in more than one jurisdiction, if it's more than the UK, the UK will might deal with assets in the UK. For an asset may need local advice or wills, and your domicile. A person has got one domicile at any given time. It is a domicile of birth, a domicile of choice, or a domicile of dependency. So you're always having a single domicile. Although someone can have multiple residencies, habitual residencies, someone might spend 6 months in the UK, 6 months abroad, or they might change their habitual residence and so forth. So all those things are important, and you need to discuss them with your lawyer or solicitor. Consider cross-border planning as well. So, in as much as you consider cross-border wills, you might also consider cross-border planning. If you've got to take wealth advisors across all jurisdictions, you might have to talk to them as well to help you manage your assets. Wills and children. In your will, you can appoint the guardians of your children. You can set up the trusts for your children, particularly if they are minor children. Of course, there will be minor children um, that you have to put up a trust for them. So you might say the trust is going to look after them until the age of 18 or 21 and so forth. And then there's going to be the executors and the trustees. So you might, because they will be under the age to be able to execute those duties themselves because they are still minors. And you can also plan for their education and long-term care. It's also crucial for blended and special needs families, where there could be difficulties or special conditions that apply in these families. So it is important to have um, a will so that it will be able to deal with all these circumstances which are ordinarily will cause um, problems for people. Some people, in terms of their culture, in terms of their religion, in terms of where they live, and so forth, it's important to have a will to cater for all those things. What are the key takeaways? Number one, a will is essential for asset and family protection. Without one, the Lord decides who inherits. So don't lose the power to decide who inherits and how. Do a will. At Tanlo Solicitors, who can help you to make a will. You can go to any other lawyer, or you can do it here yourself through the other means that I've explained in this presentation. It is important that you can have a will. If costs are an issue, there are some charities that do it for free or for a subsidized fee as well. You need to update your will regularly after major life changes. So, if you were single and you're now married, you might have to consider making a will, um, whether it's going to be a mirror will or not. That's another point there. As I've said, there's different types of wills: a single will, a mirror will, a will with a trust, and so forth. So there's a different types of wills, property will, and so forth. There's different types of wills that are out there. So anything that is life changing, getting married, having children, children turning over 18, acquiring other assets, disposing of other assets, etc., you need to update your will. Get legal advice for complex and international estates. That is very important as well. These are our contact details. I'm the presenter, Andrew Nyamayaro. You can contact us on the details on the screen. Please like our Facebook page, Tanlo Solicitors, and also subscribe to our YouTube channel. I will be presenting again to you next week as I do it every Tuesday, 7 p.m. Thank you so much. You have a good day.